We don't have a lot of carve-outs when it comes to civil rights laws.
Sure.
Because the purpose of a civil rights law is for people to be treated equally in civil society. But we have a couple, and the most famous one is probably in the Housing Act.
I'm Mitch.
And I'm Missy.
We're co-workers.
He's the boss, and we're married.
And she's the boss. Together, we host Good Faith Weekly, a podcast on faith and culture.
What could possibly go wrong?
Tune in and find out. Missy. Welcome to Good Faith Weekly. On this episode, Missy and I are going to catch up, and then later on the pod, we sat down with Jennifer Hawks, who's the Associate General Counsel at the BJC in Washington, D.C., an organization that protects the wall of separation between church and state and fights for religious liberty. It's going to be a great pod, so stay tuned. Hello there, Missy. How are you this week?
I'm great. How are you?
I'm doing very well.
I was thinking that today we might do something a little bit different.
Dear Lord. Do I hear the train coming down the tracks?
In advance of our conversation with Jennifer about the Supreme Court, I thought it might be fun to take a little Supreme Court quiz.
Okay.
Actually,
I am not a legal scholar, you know.
You are going to take the quiz.
That's what I was afraid of.
How much did you pay attention in school when you were learning about the Supreme Court?
0.
Okay, well, since I did pay attention and have all of these fun facts in my head, you're going to get to take the quiz.
Well, you went to school in Texas. I went to school in Oklahoma.
Yeah, so, take that for what it's worth. But no, I didn't either, and just knew that, the Supreme Court, honestly, was just kind of this boring unit you did in school.
Sure.
And it was an entity that, you paid attention to, but for the most part, they were kind of a benign, facet of government. Mm-hmm. That has since changed in the last several years. We have all gotten quite a civics lesson, and now it is definitely...
Well, we certainly know more about the Supreme Court than we ever did. It's always been an important arm. It's the third branch of our federal government.
Okay, let me clarify. I don't want to say it's benign. I'm just talking about in terms of knowing that the daily goings on and waiting with anticipation of, oh my goodness, the Supreme Court.
Sure.
That's what I meant.
Yeah,
it's
absolutely.
a very, very, always has been a very, very vital piece of our government structure. Just in terms of the amount to which you pay attention on the day to day, I feel like has changed.
Absolutely, 100%.
So, are you ready?
No. let's proceed anyway.
Here we go. When was the Supreme Court established and where did it convene?
I'm going to say 1801 in Philadelphia.
Well, that's not too terribly far off. It was established in 1789, first convened in New York City in 1790. The court was later moved to Philadelphia and then to Washington.
Okay, well,
so,
not too far
you're
off.
You're adjacent. How many judges have served?
Total?
Mm-hmm.
Oh my gosh, I would have no idea. I'm guessing...
You just have to take a stab at it.
125?
Man, you're not too far off. 116.
Yeah.
Okay, great. Why don't American judges wear wigs?
Because we're American and we're not British. because our judicial system is based upon we are the people, and it's not a class.
Yeah, you're going way deeper on this one than it is. I pulled this question specifically.
We have better hair than the Brits? I don't know.
I pulled this question specifically because of the person it referenced, Thomas Jefferson.
Oh, okay.
He hated wigs, so much so that when one of the Supreme Court justices, Justice William Cushing, showed up in 1790 wearing one, he said, "If we must have peculiar garbs for the judges, I think the gown is most appropriate."
Did he say it just like that, too?
I'm sure he did. But for heaven's sake, discard the monstrous wig, which makes the English judges look like rats peeping through bunches of oakum.
Well, that sounds like Jefferson. He was a Francophile, and so he did not like the British a whole lot.
Right. So I thought you would appreciate that particularly. Which two justices appear on U.S. currency?
Wow, there's two justices on U.S. currency?
Evidently. Oh, actually, wait. I did remember this from civics class, yes.
No, you didn't. Oh, my gosh. I'm going to say Taft.
No.
Okay, that's not one.
You want me to just tell you?
Brandis, Hugo Black.
John Marshall is only one of two
Thurgood
justices
Marshall.
to appear on U.S. currency, John Marshall. And then he was on the $500 bill while Salmon P. Chase was on the $10,000 bill.
Really? I have no idea.
Neither bill is in circulation today. So John Marshall and Salmon P. Chase.
So it's John Marshall, not Thurgood Marshall. Okay.
Yeah. Okay. The $500 bill and the $10,000 bill,
Gotcha.
which are not in circulation. Nor would I have ever seen either of
Fell
those.
that one.
Who was the only U.S. president to serve on the Supreme
William
Court?
Taft.
Dadgummit. Okay.
Ding, 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 ding.
What else? What other fun fact do we know?
Thank you,
about Taft?
Doris Kearns. Good one for that one. What?
What other fun fact do we know about Taft?
That he was the president, that he also threw out, he got tired and stood up during the middle of the seventh inning at a baseball game and thus began the seventh inning stretch.
Of course you would say that. I was saying he got stuck in a bathtub. But we'll go with your baseball reference.
He was a big dude.
So how many courts have we had and what categorizes them?
How many courts have we had? Boy, that's a great question. I would say probably 20.
17.
17.
Not too far
And
off. What categorizes them?
It is a chief justice. So if whoever the chief justice is, like right now, it's the Roberts Court.
You're so smart.
I wouldn't say that, but go ahead.
You're so smart. You're so smart. You're so smart. Who was the only justice to be born outside of the U.S.?
No way. There was a justice born outside the U.S. I have no idea.
And you're going to understand why I pulled this as a fun fact, because his name is Justice David J. Brewer.
Oh, you related to him?
I don't know, but Brewer is my maiden name, so I had to pull that. His family were missionaries. He was born in the Ottoman Republic in 1837.
Wow, that's impressive.
It says his mother's brother, Stephen Johnson Field, lived with the family. Both Brewer and Field became Supreme Court justices and served together on the bench.
Nice. Very
Fun
nice.
fact, huh? How is seniority decided when two justices take their oath on the same day?
Oh, wow. On the same day. I guess arm wrestling is out of the question. Even
also,
that would be
it's
awesome.
Wrestling with an E.
No, when you're from Oklahoma, it's wrestling.
Wrestling.
I'm going to say it is time served on a federal bench.
No, that's not correct. It is age.
Really? Wow. Okay.
Yep.
There you go.
On January 7th, 1972, Lewis F. Powell Jr. and William H. Rehnquist were both sworn in on the same day, and it was determined by their age.
Really? Well, that's interesting. Huh.
It does not say here which one got it, and since I was not born in 1972, I don't know.
Okay, well, as a 2-year-old, I can remember opening up the New York Times and Washington Post that day and recalling that momentous occasion.
Okay, so that's the end of our questions, but I have another little funny thing I read. The second Chief Justice only lasted a few months on the job. John Rutledge was a recess appointment to the court in 1795 to replace John Jay. However, Rutledge criticized Congress in a public speech, and a few months later, the Senate rejected his permanent nomination to the bench. I felt like that might be a little bit parallel. I don't know. But can you believe that someone was not appointed because they publicly criticized?
Oh, I cannot believe it. Scandalous.
I mean, that was pretty funny, I thought. So,
Oh, my goodness.
and then the Supreme Court did not have a fully functional home until 1935.
Yeah, because they met in Congress for a long
It
while.
says they were in various locations before the Civil War, and it was housed in the old Senate chamber from 1861 to 1935.
Believe it or not, you and I have actually seen that chamber.
Sure.
We took a tour of the Capitol with a former representative from Texas,
Chet
Edwards,
Edwards.
and he took us into that chamber, and it was really cool. A lot of statues.
Yes, lots of statues everywhere. And then the justices really did, quote, ride the circuit and hear cases around the country. That was a sticking point with some justices who didn't like to travel extensively. The requirement meant justices of the Supreme Court were mandated to preside once a year over the circuit courts located throughout the country. The requirement wasn't technically lifted until 1891.
Wow.
So there you have it, your fun facts of the day.
Oh my gosh. Well, that was a lot of fun. I mean,
Sure.
not only is this podcast fun and challenging and inspirational, it's educational
It's
too.
educational.
So thank you so much for that civics lesson. I really appreciate it.
I'm desperately hoping that we can maybe someday go back to the point where we don't wait, on the edge of our seat every day for Supreme Court decisions, but I don't think that's coming.
Yeah, I think that cat's out of the bag.
But Jennifer does a great job of breaking down a couple of the cases that have already been through the Supreme Court and some upcoming cases. And so you'll want to stay tuned, listen, and learn. Hey listeners, check us out online at goodfaithmedia.org and follow us on social at gfmedia.org. We'd love for you to subscribe, rate, and review the podcast. I'm new here and could really use the feedback, but only if it's glowing. Thanks for listening.
Welcome back to Good Faith Weekly. On this episode, we are joined by Jennifer Hawks. Jennifer is the Associate General Counsel at BJC. She provides legal analysis on church-state issues that arise before Congress, the courts, and administrative agencies. Hawks also assists in education efforts and responds to pastors and other constituents who have questions about church-state matters. Before coming to BJC, Hawks was the Director of Advocacy and Outreach Services for the Family Abuse Center in Waco, Texas, where she conducted a legal clinic and led educational programs. She previously worked for 2 judges in the state of Mississippi and served as a staff attorney for the Mississippi Department of Human Services. Hawks also served in both paid and voluntary ministry positions in Tennessee, Mississippi, and Texas. She has published papers in the Journal of the Texas Baptist Historical Society and Baptist History and Heritage Journal. A graduate of Mississippi College and the University of Mississippi School of Law, Hawks also earned a Master's of Divinity degree from George W. Truett Theological Seminary at Baylor University. She is a member of the U.S. Supreme Court, Texas and Mississippi bars, and she was ordained into the gospel ministry by McLean Baptist Church in McLean, Virginia. Jennifer, you're a busy woman. Welcome to Good Faith Weekly.
It's good to be here. Y'all have interviewed so many of my friends. I'm excited to join the party.
Excellent. We're so glad you could join us today, Jennifer. So it's apparently Supreme Court season. I'm going to refer to this
Supreme Court season, yes. The kickoff was this last Monday.
Season. Yeah. Is that okay with you?
They robed up on the gridiron.
We're going to run through the paper the football games. Okay. Anyways, we'll get back to more serious matters here. But there are several cases before the court that the BJC is going to be watching and working on. But before we talk about this upcoming term, let's revisit a couple of decisions handed down earlier this year. Carson v. Macon and Kennedy v. Bremerton are the 2 cases we wanted to maybe discuss for a few minutes pertaining to religious liberty and church-state separation. First, Carson v. Macon. Can you explain the facts of that case, the court's ruling, and what it means to us now?
Well, I'll do my best anyways. So Carson versus Macon came out of the state of Maine, and it's a funding case. How much government funding with religious institutions should we have? And this was in the context of school vouchers. So Maine has a unique public school funding program because of the state's remoteness and low population density in some of its counties. They simply cannot support a public high school. There's just not enough students to be able to justify a building and teachers and all that goes with running a public school. So the Maine Constitution requires that all students receive a free and public education. And so the Maine legislature had to figure out, how do we provide this public education for these students where there's no ability to have a public high school? And so they created a program where school districts can choose another public high school to send their kids to. So we're going to send our kids to the next county over, or school districts could designate a single private school, and we're going to pay for tuition at this one private school, and all of our kids are going to go there. But there was also a third prong to the program that school districts could just choose, we will pay a certain amount of tuition assistance, and parents can choose from any approved private school. And to be an approved private school, one of the conditions was that you did not teach your curriculum from a religious perspective. So you were a non-sectarian school. You can be religious as a school, but your curriculum had to be, the equivalent of a public education. And so a couple of families sued because they wanted to send their kids to both of these families happened to be Christian and wanted to send their kids to Christian schools that did teach from a Christian worldview. And so their schools were not on the approved list. The case makes it all the way up to the U.S. Supreme Court. And so the question before the Supreme Court was not, could Maine have included schools that teach from a religious worldview in their curriculum, because the court has already ruled that they can. States can include those if they choose to. So the question before the court was, must the states include these types of schools? And so we had oral arguments, briefing, and the court handed down its opinion during its last 7 days back in June. And the court ruled that the state of Maine has to include the religious schools that are teaching from a religious worldview if they have a program where parents get to choose tuition or get to choose the location where the dollars can be directed. The decision was really an expansion because the question flipped from may to must.
So Jennifer, let me get this straight, because we know that this is happening all across the country. I know you very well. I know the work of the BJC. You're very passionate about advocating for public education and the funding of public education, as well as keeping church and state separate. So what I want to get straight is this. All across the country, there has been an attempt by conservative state legislatures to defund public education. And the more they defund public education, the larger the problem goes into fulfilling those obligations by state mandated constitutional guidelines, such as providing a free education to every child in those states. So they have created the problem. Now they want to come in with their own solution. And what we're hearing is that now there is the possibility, well, not the possibility, the reality that states are directly funding religious education within these schools. So I'm guessing that there are some violations even within their own state constitutions. Is that correct?
Potentially. I mean, that's the theory that these cases are brought under. But this case was brought under the federal Constitution free exercise clause. And the court ruled that it violates the federal free exercise clause for Maine to deny these parents the ability to choose a religious school when they have a choice of options. So if Maine does not have that option, like I said, there were the three prongs. If they don't have that third prong, then there's no requirement that religious schools with a religious worldview be included in the program. But once the court has ruled, once a state opens it up to where parents have the choice to send the money, in the court's view, that's what breaks the constitutional problem. It's not the state choosing to fund the religion. It's the parent making the choice, but pulling from the state-funded dollars. BJC still opposes school vouchers. Right. We think it's bad for religion because with government money always comes government strings. They may not be immediate, but they always end up coming. And as taxpayers, I think we all want accountability in how our taxpayer money is spent. So that's where those strings come from. One of the unique things that has happened after this case, which isn't totally unexpected, is that there has not been a rush of religious schools in Maine to sign up for the program. Right. Because you have to abide by Maine's human rights law, which impacts the student you can admit. It impacts your hiring practices. And so most religious schools in Maine have chosen to not apply for the program, at least not yet. So, I mean, the decision came down in June. Applications were due sometime over the summer. So perhaps next summer there'll be more. But the last news story I heard, only one private religious school in Maine had applied to become part of the program. And that one was not either of the schools that was the subject of the lawsuit.
Wow. So basically what they're saying is we want the money, but we don't want to be decent and humane about anything. So well, I mean, that's me saying that, Jennifer. You can distance. So I understand.
Well, it's also who brought this case. This case was brought by parents. This case was not brought by the school saying, let us into your program. Right. And the parents are sympathetic plaintiffs because all parents want what's best for their kids, and this is what these parents think is best for their kids, and they feel that they're being treated differently from other parents in the state. Again, a very small percentage of other parents in the state, but the equities perhaps balance out differently if the schools themselves had been the ones to sue, saying we're being treated differently because you don't let people choose us.
Sure.
So it's just one of those things that's going to be, that we'll continue to watch. But the ability for states to attach non-discrimination strings to taxpayer money is one of those questions that's an open question that will eventually be answered by the Supreme Court at some point.
Okay. Well, Jennifer, thank you so much. I mean, that case is extremely important for many other states across the country when it comes to school vouchers and keeping church and state separate. So thank you for explaining that. But let's move on to a really popular story over the last year, and that's Kennedy versus Bremerton. The case garnered much attention because it dealt with three of America's greatest pastimes: religion, politics, and football. Again, can you explain the facts of the case, the ruling, and what it means for us now?
This is one that it's hard to explain the facts because the majority opinion and the dissenting opinion have two very different views of the facts. And so I will describe the facts as I think is a true telling of them. Coach Joseph Kennedy was a part-time junior varsity football coach for the Bremerton High School in Bremerton, Washington. And he had a practice of leading his players in prayer in the locker room before the games and giving religious motivational speeches. And then after the game, he would pray on the 50-yard line and players would join him. At some point, he starts inviting the other team, and it's an opposing team coach that goes to the school district and informs the school district that you have a coach who's praying on the football field after the games, surrounded by players. And so the school district comes in and says, "Hey, coach, you can't do this. This violates the line. We're supposed to be about protecting students' religious freedom and not coercing them into religious practices." And so Coach Kennedy agrees to give up his pregame practices, the locker room prayer and the motivational speech that was based on religious language. But he insists that he has a free exercise right to continue to pray on the 50-yard line immediately following the football game as his expression of faith. And the school district says, no, you can't do that. And so they have this period of time where they're negotiating. And so for about a month, he does not go to the 50-yard line following the football game. In one game, he comes after everyone has left, and other games he does other things. During that month time frame, no students went to the 50-yard line to pray. So there was something about the presence of the coach. I'm not saying he forced them to be there, but there was something about the coach's presence that was important for the students to be on the 50-yard line immediately following the football game. And then at some point, he decides that he's going to resume his practice, and so sends out some social media messages saying that he's going to do it. And then for that game, there was mass chaos because people rushed the stands to come and join him, other members of the community. A couple band members got pushed over. It was just a chaotic scene. And then there were two more games in the football season, and he prayed on the 50-yard line after those games. And none of his players joined him for those last three events, but some members of the community came in from the stands. And so the Bremerton School District put him on paid administrative leave while they were trying to work out what was happening. He chose not to reapply for the following year. Like many school districts, assistant coaches of this sort are on one-year contracts. And then he sues the school district, saying that he is being discriminated against and that they are preventing him from engaging in a prayer practice. Case comes all the way to the Supreme Court. He had lost below. Seemed like a pretty slam dunk for the school district. He was still in his official coaching capacity. Students were around, and but when it comes to the Supreme Court looks only at the last three games. So when his players weren't around, and say that and basically took a microscope to the facts to narrow it down and say that a school district cannot prevent its employees from engaging in a religious practice when employees can engage in personal time and students aren't present. And so they equated it to the coach sending a text to his wife, the game's over. I'll be home in 30 minutes.
So let me get this straight. They only looked at the last 3 games. They did not look at the totality of his actions.
Yes. As far as the majority opinion is concerned, students were not engaged or involved in the practice. They just looked at the rights of the coach as an individual. And teachers and coaches do have the right to engage in religious practices. Sure. There have just always been boundaries when students would be present, that if there's a potential conflict between the rights of teachers and the rights of students have to prevail, because the job of teachers, one of their many hats that they wear, is protecting the rights of our students.
Sure. So Jennifer, let me ask you this. How does the Supreme Court decide that? Is that in the suit itself, or does the Supreme Court say, okay, we're not going to look at the totality of evidence in this case. We're only going to look at this minute part of the evidence to come to our ruling? Who decides that? What's the process there? Because I didn't know that. That's new information to me.
The school district brought it focusing on those last 3 games, but they focused on those 3 games, but saw them as part of a long, multi-year practice of doing this. And the court just ignored the multi-year practice. And so that's why the majority and the dissent are different. The dissent actually puts in pictures of him praying on the 50-yard line with students around him, just to point out, this is what was actually happening. We can narrow the facts as much as we want, but this is what was going on, and this is what the court is upholding. And so it's going to be interesting going forward, how lower courts interpret this. Do they look at the very narrow dissection of the facts that the majority put forward, or do they see that as upholding something broader of what was going on? The court did not say that teachers have a right to lead students in prayer, which is something we've been hearing from pastors and from others of, that's what the court held. That is not what the court held. But it certainly looks like they may have taken a step in that direction.
So, you just have illustrated the importance of looking at these cases and understanding them in their context and reading the nuances of each ruling, because this is significant. And I'm just so thankful there are organizations like BJC and lawyers like yourself out there protecting that hedge of protection between church and state. And well done. Thank you so much for explaining that to us.
Well, they're trying to, Mitch.
Yes, somebody keeps, I use William's metaphor of the hedge. Someone keeps coming in there and cutting the hedge way down low.
Yeah, they're certainly carving some walking lanes in that hedge.
Absolutely. Those only flow one direction, though, probably. Well, let's move on and talk about this year's term. And let's take a moment to recognize the historic start of this year with Justice Ketanji Brown Jackson beginning her service on the Supreme Court. She is the first Black woman in our nation's history to serve as a Supreme Court justice. Talk to us about what this moment means for our country.
I think it's really significant. Her investiture, so when she actually took on the role, was a week ago. And it's a significant moment to have, a Black female on the court and her voice and her perspective and her questions. And she jumped right in Monday with questions. And so that was really exciting to see. It usually takes a couple of years for a Supreme Court justice to really find their feet and their groove. So, I'm sure it's going to develop, but it was really exciting to see her immediately jump in and have questions and deep probing questions. And so, I'm excited to see where it goes. And also there's also a little bit of return to normalcy, that the courtroom is once again open to an audience. So members of the press can come, members of the bar can come, members of the public can come in. So we're seeing lines in front of the Supreme Court again on argument day. So it's got a little more of that, kind of a DC feel. So I have not yet been in the courtroom yet to see Justice Jackson, but I'm excited for that day when I get to look up and see her on the end there. And it's an inspirational story to so many in our country, that you really can achieve your dreams. And well said. that hard work and perseverance really can pay off. She has an amazing pedigree. She obviously deserves to be up there, and I'm excited for the potential of her being in the room. Her parents were public school teachers, and when they're in conference, it's just the justices. There are no clerks. There are no assistants. There's no press. And so, I'm really hopeful that her presence at the table can maybe move the needle just a bit, the way Ginsburg was able to do, and some of the other justices who formerly served.
Well said. Jennifer, the court has taken an extreme right turn, it seems, in some of its rulings over the last year. Some are even saying the court is now a pro-religion court. What does that mean overall for religious liberty, especially in church-state separation cases?
Yes, so this court is certainly interested in religion and religious freedom cases. So, historically, one maybe case would be taken a year. Last year, we filed 3 briefs, and then there was another case that we had to monitor closely and report on. And so it's certainly a topic that they like. But they're being called the pro-religion court because the religion claimant has been on a winning streak. And the problem is the religious claimant side isn't always the most protective of religious freedom for all people. And so BJC's executive director and general counsel, Amanda Tyler and Holly Holman, wrote an op-ed that USA Today published this week, talking about how the religious side isn't always it shouldn't be the default answer for religious freedom for all. And so we're really excited about that op-ed. It really lays out some of our reasoning for that. And, but it's important that we protect religious freedom for everyone. Because once the government gets to pick and choose religious winners, at some point we could be on that losing side. So it's in our best interest as Christians to ensure that everyone is protected, and that will help ensure that we are protected as well.
Absolutely.
Along those lines, the court's going to return to the issue of whether a business can refuse to provide wedding-related services to customers in protected classes based on the owner's religious belief. While the 303 Creative versus v. Elenis case will be heard on free speech grounds and not religious grounds, can you explain the religious connotations?
Absolutely. So this is, if your listeners remember back, there was a case a couple of years ago about a wedding cake. And so that was
we all remember the wedding cake, Jennifer. By the time that case was over, I was wanting to throw some cake at people, but go ahead.
So this is also out of the state of Colorado. So a lot of it is very similar to the cake baker case. And so the cake baker case was both free exercise and free speech. And Justice Thomas wrote a free speech concurring opinion, but most everyone else had focused on the free exercise. And in that case, basically, the court ruled for the baker, but in a way that doesn't really help anyone else. And so the court found that the way the baker had been treated in the process of bringing the suit against him violated his free exercise, but they did not rule on whether or not he was correct in denying service and whether he would have that ability going forward. So it's an open question in Colorado. And so for this case, for 303 Creative is a website designing shop. And so the owner of it, the creative designer, her Christian beliefs is that marriage is reserved between a man and a woman, and that her website design is her speech, and it shows her support and approval. And so therefore she does not feel that she would be able to create a wedding website for same-sex couples. And so she sued the state of Colorado saying, you can't enforce your non-discrimination law against me and make me provide websites to same-sex couples because of my free exercise rights and my free speech rights. She lost in the courts below, appealed to the U.S. Supreme Court, and the U.S. Supreme Court took the case, but only on the free speech grounds. So she asked the court to consider both, and the court said, we'll take your case, but only as a free speech case. And so they're going to be looking at, free speech doctrine. When can the government make you do something? And so that's what makes this a little bit different, is that we do have very robust free speech laws in this country that protect all kinds of speech. And so that's what this case is going to be focused on. But there's certainly religious elements because her speech is from her religious beliefs. And it's from her desire to run her business in accordance with her religious beliefs. But we have a long history of businesses being discriminatory in this country. And so public accommodations laws is one of the ways that the state tries to combat that and ensure that all customers are treated equally and not discriminated against because of certain categories. And every state is a little bit different. And Colorado does include sexual orientation and gender identity as some of their protected categories.
So, Jennifer, this is a fascinating case for me. I've been following it. Obviously, at Good Faith Media, we are a totally inclusive and affirming organization. But I understand the hesitancy to begin to limit free speech and free exercise of religion. And what's fascinating to me about this is that there is precedent from the Supreme Court, even though I would disagree with that precedent, of treating companies, especially closely held companies, almost as individuals rather than just a pure business, as though a business has a conscience. But that's another debate. What's interesting to me about this is that if we were to take this particular circumstance and put it in the South in the early 1950s, could an owner of a diner argue these same arguments or make the same argument for segregation based upon their free speech and religious convictions, that they will not serve black customers because it violates their free speech, it violates their religious conscience? So could the argument that they're making now, is that not the same argument that was being made during segregation?
Yes, it was certainly an argument that was being made by segregation, or in the days of segregation. One of the most famous cases that is in that vein is the Piggy Park case. And so it was a barbecue joint. And there's the Civil Rights Act was passed. And so now all restaurants cannot discriminate on the basis of race when serving your customers. And so the owner of Piggy Park said, we'll sell barbecue to our black residents, but we're not going to let them sit in the dining room. So it's basically like a to-go window.
Sure.
So they can get the food. We'll serve them, but we're not going to do this extra service for them because that would violate my religious belief that the races should not be mixed. And the court, essentially laughed them out of court and said no, like that you're going to serve them. Law requires you to serve them, and that's the end of the story. That was before the days of RFRA, and so perhaps it's different. The people making the claim now, of course, do not want that comparison to those earlier days, and they say it's very different because even in this case, in the Kate Baker case, the business owners are saying that they will serve the LGBTQ customers. They just don't want to do this one specific service for them. And what's hard about this at the Supreme Court level is the Supreme Court is looking, potentially to say you as a business owner have a free speech right to say no to a customer in a protected category because of their protected category. It would be different if this was in the legislature, because a legislature could create some kind of carve out.
Right.
If your business has less than 10 employees, and it's, a single proprietorship, or, they could put whatever size limitations they want on it. They could put specific categories. You don't have to provide wedding services. You don't have to provide funeral services, any other thing that they want to put in there. But it would be a cabined off exemption. And then the court would be looking, do you fit within this exemption? But if the court finds that there's a constitutional right to say no to a customer, there is no limitation for that. Mm-hmm. And so it could be taken, into any, it could be taken any number of directions. And I think that's one of the things that happened with the Cake Baker case, is the court wanted to rule for the baker, and they found a way to do that. But I think they tried really hard to find a way to rule for him on the question that they were being asked about serving customers. Sure. And couldn't find a way to do it that limited it so that it doesn't completely undercut our public accommodations laws and other non-discrimination laws that state, local, and federal governments have. Mm-hmm. And so it's a hard question. We'll see, if the court can find a creative third path, if they're interested in that.
I think I know the answer to that, Jennifer.
One possible third path, I don't think the court's going to do it, but another one of her complaints is that the Colorado law doesn't allow you imply that you may not serve. So she can't post, or she says that she can't, in her About Me section on the website, talk about her strong Christian beliefs and how marriage is only between a man and a woman. So, it's possible there's some kind of third path of, a state, it goes too far for a state to limit the ability of a business owner to describe themselves and their personal beliefs, as long as they're willing to provide the service. But it's a hard question. We don't have a lot of carve outs when it comes to civil rights laws, because the purpose of a civil rights law is for people to be treated equally in civil society. But we have a couple, and the most famous one is probably in the Housing Act. So in the Fair Housing Act passed in the 60s, one of the complaints that was being brought up by legislators who were opposed to it is it's called the Miss Murphy's exception. The hypothetical that the proponents of the Fair Housing Act kept running into from legislators who were objecting what was this idea that there was this hypothetical Mrs. Murphy who was an elderly white woman and low income or needed more income, and so she decided to rent out rooms in her house. And so this stranger that she doesn't know, who's from a different race, comes and knocks on her door and says, I see you have an ad for a room. I want to rent it. And so the objection was, are we really going to force this Mrs. Murphy to accept anyone who comes and knocks on her door in response to her ad? And so to get past that hypothetical, which is very sympathetic, and if it's someone's home, I don't know that we want to force people to open up their home to every Tom, Dick, and Harry that might come along. And so they created an exemption, and the exemption is, if you're renting out 4 rooms or less in a property you live in, you don't have to abide by the Fair Housing Act. So you can discriminate, you can pick and choose, and so that was the way to get around that exemption. That was not a court-created exemption. That was a legislative solution. And so if we want some kind of narrow exemption to work in, that's a legislative fix, and that's not a court fix, because the court can't do that. If the court finds a constitutional right, then there's a constitutional right that would apply across the board to everyone.
Oh, it makes perfect sense. And something exciting, not only was the court opening this week, but something also was exciting happening at BJC. So tell us a little bit about that.
Amanda and Holly have an amazing podcast. It's called Respecting Religion, and season 4 launched yesterday. And they launched with a live episode on Facebook Live. So that's the first time that's ever happened, which is always awesome. And so you can check it out on any of your major podcast providers. So just search for Respecting Religion. You got 3 seasons you can catch up on in your free time, but it's going to be a weekly podcast. And Amanda and Holly talk about cases, they talk about legislation, they talk about stuff they're seeing in the news, and all the ways that we need to be respecting religion in our society.
Jennifer, thank you so much for our civics lesson today. I very much appreciated it and actually paid attention.
There will be a quiz after this.
I was not passing notes to the cute boy in class instead of listening.
Hey, wait a minute. Are you not passing notes, or am I not the cute boy?
Anyways, I digress. But as you know, our tagline at Good Faith Media is "There's more to tell." In light of your work at BJC and our conversation today, what is your more to tell?
That's such a great question. And we've had a really heady conversation, so I'm going to go a slightly different direction. And my more to tell is that we should try new things and feed our curiosity and our creativity. One of my things that I've done moving up here to Northern Virginia is I joined the handbell choir at my church. I am not musical, but I've always enjoyed handbells, and they let me come in. Every one of the choir is fabulous. I'm the I'm the ball and chain that holds us back a little bit, but it's a welcoming group. It allows me to exercise some different muscles, and so it's some good time of fellowship and some creativity that I wouldn't otherwise be able to express. So I would encourage everyone to not be afraid to try something new and find a way to feed your creativity and curiosity.
Well, Jennifer Hawks, thank you so much for joining us on Good Faith Weekly this week. Your explanations of the cases, your analysis is just incredible. Again, we want to thank you and BJC for standing in the gap and standing on that wall, protecting the separation of church and state and the free exercise of religion in this country. You're doing incredible work. God bless.
Thank you, Mitch and Missy. It was a pleasure to be here.
You've been listening to Good Faith Weekly, hosted by Mitch and Missy Randall. This weekly podcast from Good Faith Media discusses matters of faith and culture.
Subscribe wherever you get your podcast and give us a like and a glowing review. We produce the podcast out of Norman, Oklahoma. Our music comes from Pond 5.
And we're supported by listeners like you. Learn more about us at goodfaithmedia.org.